kinds of things they want to say he's racist. He really just loves Americans and is trying to protect families.
Ainsley, as you know, he loves America. President Trump has made America safe again, and that's what he's doing. And in turn, that makes Americans feel safe to go to work, to have jobs, to be able to go to church, to be able to function in our country and be safe. And that's what's driving our economy. Donald Trump making America safe. And that's why our economy is at a record high.
Something is catastrophically breaking down inside the United States Department of Justice right now that federal judges across the country are documenting in real time in their written opinions. And when you read what those judges are actually saying, you are going to understand why legal experts are calling this the most serious institutional collapse of a law enforcement agency in modern American history. Because this is not a story about policy disagreements between judges and prosecutors. This is not a story about aggressive enforcement strategies being pushed to their legal limits. This is a story about a Department of Justice that has lost so many experienced attorneys to resignations and firings that it cannot perform the most basic functions of legal representation, cannot meet deadlines, cannot respond to motions, cannot provide courts with accurate facts about the human beings whose liberty is at stake in the cases it is supposed to be litigating. And people are sitting in detention facilities right now because of it. Make sure you're subscribed to The John Brown Show, because what I am about to walk you through represents the convergence of two catastrophic failures happening simultaneously. An enforcement operation sweeping people into detention at unprecedented scale, and a legal apparatus so hollowed out by the exodus of qualified attorneys that it cannot legally justify the detentions it is creating. Those two failures colliding inside federal courtrooms every single day. Here is the case that captures everything wrong with what is happening right now. A man was detained by immigration enforcement. The government's justification for that detention was a criminal conviction for marijuana possession in 2009. A federal judge in West Virginia examined that claim. The judge found that the man being detained was 4 years old in 2009. 4 years old. The criminal record the government used to justify taking away someone's freedom and throwing them in a detention facility belonged to someone with the same name, but different birth date, different birthplace, different parents' names, and different immigration status. The government either did not check or did not care about any of those differences. Share this video because the judge's response to that finding tells you exactly how seriously the federal judiciary is taking what it is seeing from this administration. The word the judge used was sloppiness. It appeared in the ruling repeatedly, but the judge went further than describing a bureaucratic error. The court wrote that this pattern of sloppiness further validates serious concerns about the procedures being used to deprive people present in the United States of their liberty. Those are not the words of a judge describing an isolated mistake. Those are the words of a judge documenting a systemic pattern that multiple courts across the country are independently reaching the same conclusions about. The chief judge in Minnesota went even further. In remarks directed at the administration's legal team, she stated that they had violated more court orders in a single month than most agencies violate in an entire lifetime. 1 month. More violations than an entire lifetime of normal agency conduct. That is not a rebuke of a department making occasional errors under pressure. That is a judge describing an agency that has decided court orders are optional. Think about what it means for a law enforcement agency to be told by a federal judge that it violates more court orders in a single month than most agencies do in their entire existence. And to keep going, make sure you're subscribed because the DOJ staffing collapse driving all of this is not an accident. It is the predictable result of a deliberate dismantling. Thousands of experienced Department of Justice attorneys and staff have departed, fired, forced out, resigned rather than execute policies they believed were unlawful. The institutional knowledge that walked out of those buildings represented decades of experience in immigration law, constitutional litigation, habeas corpus proceedings, and the procedural requirements that govern how the government must treat people it takes into custody. When that expertise leaves and is replaced by attorneys who have been conscripted from other positions with no immigration law background, The predictable result is exactly what federal courts are now documenting: missed deadlines, unanswered motions, cases where the Department of Justice appears in court and tells a judge it has no opposition to arguments being made on behalf of detained individuals, not that it disagrees with those arguments, not that it needs more time to respond, that it has no counterargument, that it cannot defend the detention it created, and the judges are doing what the law requires when one party presents arguments and the opposing party offers nothing. They are ordering releases. Share this video because the pattern of what happens after those release orders is the part of this story that a former federal prosecutor just described as more than sloppiness, much more. When courts order detained individuals released, the administration has a legal obligation to comply. What is actually happening in practice is something federal judges are now finding individuals in civil contempt over. A man whose release was ordered by a court was transferred to Texas in violation of that order, then released on the streets of El Paso, without his belongings, without his identification documents, 800 miles from his home. The administration was found in civil contempt, ordered to reimburse the man for the plane ticket he had to purchase to get back. In another case, after a court ordered a man released from custody, immigration agents held onto his car keys, his family's car, 75 miles from their home. Another judge had to issue a separate order requiring the return of their property, calling the agency's conduct unlawful and inappropriate. Think about what these incidents reveal about institutional culture. A court order demanding release is not being treated as a legal obligation. It is being treated as an inconvenience to be minimized, complied with in the narrowest possible technical sense, while the spirit of the order is undermined at every opportunity. Release the person, keep their keys, dump them in El Paso with no identification, comply with the letter, violate the intent, and force them to go back to court to get what the first order should have produced. Make sure you're subscribed because what a veteran federal prosecutor just explained about the deeper pattern behind these incidents reframes everything you just heard. When a pattern of errors appears once, twice, 5 times, it can plausibly be attributed to the chaos of rapid institutional change. When the same pattern appears hundreds of times across multiple jurisdictions, with multiple judges in multiple states all documenting the same conduct, the explanation shifts. From accident to design, from incompetence to strategy, from sloppiness to something the prosecutor described directly as an attitude that has been sanctioned from the top. The strategy is not complicated. Detain people. Make the detention difficult to challenge by denying access to lawyers, denying access to belongings, moving people between facilities in ways that make it difficult for attorneys to locate and represent them. When courts order releases, comply in the most technically narrow way possible while creating maximum practical obstacles to the person actually getting free. And do all of this while the DOJ is too understaffed and overwhelmed to mount effective legal defenses when the cases actually reach judges. The detention is not designed to produce deportations in every case. Deportation is expensive, diplomatically complicated, and frequently blocked by litigation. Detention itself is the tool, holding people, having control over them, keeping them confined while administrative processes unfold on whatever timeline the agency chooses to operate on. Share this video because what is happening to the DOJ attorneys who are being put in the middle of this operation is a story that has not received nearly enough attention. Lawyers who are being conscripted from other government positions and sent into immigration court to represent the United States government have no immigration law experience. They are being placed in proceedings involving complex constitutional questions, habeas corpus petitions, and statutory frameworks that take years to master. They are being asked to defend detentions that the facts do not support against attorneys who have spent careers in this specific area of law, in front of judges who are losing patience with an agency that cannot provide basic, accurate information about the people it is detaining. Some of those conscripted attorneys are now being held in contempt by courts, having contempt findings attached to their professional records, contempt findings that appear when their names are searched. that will follow them for the rest of their legal careers, not because they designed unlawful detention operations, not because they made the decisions that produced the errors courts are documenting, but because they were placed in an impossible position by an administration that dismantled the institutional capacity needed to do this work lawfully and then pushed forward with enforcement at unprecedented scale anyway. One attorney asked a judge to hold her in contempt and detain her rather than continue working for the Department of Justice. She would rather be imprisoned than continue executing this administration's legal strategy. That is not a person making a dramatic political statement. That is a lawyer telling a court that what she is being asked to do is something she cannot in conscience continue to be part of. Think about what that tells you about what is happening inside that building. Make sure you're subscribed because the Attorney General's response to all of this is the final element of this story that ties everything together. When asked about the DOJ collapse, the detention chaos, the contempt findings, the 4-year-old criminal defendant, the car keys held 75 miles from home, the release orders being complied with through El Paso sidewalk abandonments, the Attorney General talked about the economy, about safety, about how Americans feel free to go to work and to church, about how the president loves America. Not a single word about habeas corpus petitions going unanswered. Not a single acknowledgement of the judge who said they violated more court orders in a month than most agencies do in a lifetime. Not a single response to the 4-year-old criminal conviction. Not a single explanation for why the Department of Justice she runs cannot find enough lawyers to respond to motions filed on behalf of people it is holding in detention facilities. The institution responsible for ensuring the faithful execution of American law is being run by someone who responds to documented evidence of constitutional violations by discussing the Dow Jones average. Share this video because the consequences of this institutional collapse are not abstract legal questions. They are human beings. People sitting in detention facilities right now whose cases have not been responded to, whose petitions are sitting in an inbox somewhere waiting for a lawyer who does not exist to respond to them, whose release orders have been technically complied with in ways designed to leave them stranded without identification, without property, without transportation, hundreds of miles from their families. Some of them citizens, some of them legal residents, some of them people whose only connection to the ground cited for their detention is sharing a name with someone who actually has a record. A 4-year-old marijuana conviction, car keys held 75 miles from home, $800 reimbursed for a plane ticket to El Paso, an attorney who preferred contempt to continuing, a chief judge documenting more monthly violations than a lifetime of normal agency conduct, a department so depleted it tells courts it has no opposition to release petitions. This is not a functioning Department of Justice. This is what happens when you fire everyone who knows how to run one. This story is just getting started. Stay tuned.